100 questions about a will challenge.
This is a paper written jointly by Archie Rabinowitz and Rabbi Torczyner, and its title is Obligations of Decision Makers under the Substitute Decisions Act and Halacha. Given the limited time frame, we're not going to ask the presenters to present in the regular way. What I'm going to do is to pose several questions to them related to the fact situation we had here today, and I'm going to ask each of them to comment. And as far as timing is concerned, I think we have the normal half an hour that we've given for two speakers. The first question I'd like to pose is as follows. We saw that Boris used his power of attorney to essentially gift to himself his mother's house. I'd like to know from Archie and Rabbi Torczyner, within the respective realms of law, Archie, the law of Ontario, and Rabbi Torczyner, Halacha, Jewish law, what the law has to say about a power of attorney or an Apotropis. Did I pronounce that correctly, Rabbi?
You got it.
Gifting to themselves an asset that belonged to the incapable person. Archie?
The interesting part about the fact situation was I wasn't sure if at the time the gift was made, that is by Boris acting as attorney on the instructions, I think John's evidence was, or Boris's evidence was that, I think Boris's evidence was that on the instructions of his mother, he attended or effected the transfer for $2 and natural love and affection. There was much made about the fact that $2 wasn't paid, but not too much evidence or not too much discussion in the cross-examination by Kim Whaley about the natural love and affection. So if at the time of the transfer, Mom still had capacity, the act, I'm not sure that it necessarily applies, the Substitute Decisions Act. However, there isn't an express prohibition that says that an attorney or guardian cannot make a gift generally. In fact, the Act doesn't speak directly to gifts being made to the guardian or to the fiduciary. The Act expressly permits, under certain circumstances, gifts to be made. I've always taken an ultra-conservative approach to that when acting for attorneys or guardians in asking them if they enjoy being sued, because if they do, they will go ahead and help themselves, and as Justice Ayton was describing, we often have sloppy clients who haven't really attended to the precise counsel of perfection approach in either getting court approval if there is an incapable person, in fact, because as we know, the power of attorney in this case I don't think was conditional upon a finding by a court or by a practitioner. I'm not sure about that, but correct me if I'm wrong. I think it was the standard continuing power of attorney, which simply expressly said that it is intended to continue beyond a finding of incapacity. But if I say it, as I say, if at the time of the transfer, Mom was capable, there may very well be a presumption of resulting trust, but as I understand the case law, that applies in the two cases anyways that formed the basis of that at the Supreme Court. In both instances, the transferor was deceased. In this case, we still have a living mom, but at this point is incapable, although much was made in the argument about the fact that there is a possibility that she might recover or that she might regain capacity to manage her own property. In any event, the Act puts certain conditions on it, and I think it is designed to balance the interests, to maintain some dignity and autonomy for the incapable person, and at the same time impose stringent obligations and requirements and checks and balances on the guardian or the fiduciary in making sure that the guardian doesn't take advantage of their position, of their relationship, to impair the economic well-being of the donor, in this case of the mother. So what the Act stipulates is that they can make, the guardian, the attorney, can make gifts or loans to the incapable person's friends or relatives, and can make charitable gifts, but only if the remaining property will remain sufficient to satisfy requirements of ensuring that adequate provision is being made for the donor. There wasn't any evidence, I think, of any danger that Mum had been placed in as a result of the transfer of the house. I wasn't sure if there was sufficient assets. I don't know. Typically, there might be forecasting reports of what expenses a person of that age and in that physical and cognitive state might have to face. But my advice would always be to err on the side of caution. And quite frankly, many attorneys that we act for, if we act for the attorney who comes in trying to rationalize why the gift was made, we encourage them, unless there is killer evidence, the type that I think Jordan was talking about, getting the best lawyer, making Mum get the best lawyer, not driving Mum to the best lawyer, and making sure that there is clear, corroborated evidence of an intention to make a gift, and probing by that lawyer to ensure that Mum appreciates what she's giving away, what she has left, why she's giving it away, what impact it'll have on her estate plan, and what provision has been made for her just in case the rest of her assets run out. And she then is in an even more vulnerable position where she no longer has the equity in the house in order to continue funding her health care expenses. In any event, the statute tries to balance this with two conditions. I mentioned the first one, that the remaining property has to be sufficient to satisfy the requirement of ensuring that the donor is properly taken care of. And the second one is that gifts or loans to the incapable person's friends or relatives can only be made if there is reason to believe, based on intentions the person, that is Mum, in their case, expressed before becoming incapable, that he or she would make them if capable. The problem with that, of course, is that we did have a postcard in this case. I was dying for one of the counsel to ask Boris to read and speak in Russian, which I would have paid for gladly, but it didn't happen. I thought the wording in the actual postcard was potentially ambiguous, because the last word...
Excuse me, did you say purposely or potentially?
Well, knowing if, Chuck, if you had anything to do with the fact situation, with the Slivovitz references and et cetera, I'm sure it was done with the purpose of ensuring that the issues are alive for counsel to seize upon, as depending on what perspective they come from. But in any event, the last word in the postcard was, or the last two words was, for L-I-V-E. And I don't know if that was the, if I understood the evidence, Mum is illiterate or functionally illiterate, and I'm assuming the words were written in English, and that mean to live in, as compensation for recognizing that her son was doing a wonderful job sacrificing his career in New York or wherever to come back and help for mom, or did she mean for life, possibly only giving a life interest? But in any event, it's clear that that postcard, although admitted in the statement of facts, was in the handwriting of mom, wasn't signed by her. Be pretty difficult to make an argument under current Ontario law that it was a holograph codicil. But in any event, I'd have to check the chronology. I don't know if the will revoked all prior testamentary dispositions in any event. But the bottom line is that when you take a house, which is, I understand, the fact situation represented a substantial portion of this lady's assets, not an annual gift to B'nai B'rith or to the pattern of charitable donations that mom would have given. Those are the kinds that I think a judge will, even if it's a birthday gifts to nieces, nephews, grandchildren, wedding gifts of that sort, might be justified. But once you get into the realm of a house, unless you're dealing with someone who has millions and millions of liquid assets available, many properties, corroboration from others other than Boris, which might be given, even if it was admissible, might be given very little weight, I think I would tread very, very carefully, and hence why I think we heard from counsel and from Justice Ayton just how concerned he was about the validity of that gift. It's just setting the fiduciary up for a miserable day in court because, as you saw, a lot of people were focusing their attention on what about this house transfer and what were you doing, and tell me about the circumstances of it. And it really taints, and it's a hard challenge for Boris and his counsel to overcome because they didn't appreciate at the time. I take it the evidence is that Boris didn't do this with the intent to rob his mother, and leave aside the fact that even if the transfer is invalid, even if, as Justice Penny may have done in one of the cases, and entertained a discussion about the validity of a will, even though mom is still alive, there is a potential claim that Boris might have for compensation on a quantum merit basis or unjust enrichment basis for the years of work that he's done. And so, in all likelihood, a good mediator would point this out, and even if I don't think a formal application for support or for compensation on that basis had been formalized in the case, but rest assured, with all the great lawyers that you heard from, it wouldn't take 10 seconds for that to be on the table quickly.
So, Archie, I'd like to switch to Rabbi Torczyner. And Rabbi, if you could talk to us a little bit about this scenario with the gift and with Boris and with his role as a power of attorney under Halacha Jewish law.
Sure, thank you. And thanks in general. I'm always grateful to be the non-lawyer, non-doctor sitting on the panel. I must admit that in the beginning I was a little disappointed not to be part of the entertaining part of the program, but then when I watched Kim shred Boris, I felt pretty good about where I am in the program. In terms of the question of Boris's ability to take gifts, so as an overarching principle, as I understand it, the power of attorney from the perspective of Halacha is a position called an Apotropis, which I'll come back to in a moment. The Apotropis is empowered to receive gifts, but not to take the gifts for himself. And what I mean by that is, generally speaking, the job of this Apotropis is to protect the estate. The word Apotropis itself is neither Hebrew nor Yiddish, not Russian either. It's Greek. And the meaning of it is to prevent harm, to keep harm away from the estate. So the job of this power of attorney is to protect the estate. Channeling it to himself is not really considered a legitimate use of his powers. Second, there's a major concern in Jewish law for what would be called in English gossip. There's a biblical verse, Haser mimcha lizut sfatayim. Keep the murmurings of people away from yourself, meaning don't act in a way that's going to cause people to suspect wrongdoing. And so there's a discussion, for example, let's say this Apotropis has a business venture and he wants to invest part of his charges, assets in his business venture. He's not allowed to do that, even though it could be 100% legitimate and even though he invests his own funds in it. Nonetheless, he can't do that himself because of concern for what people will think and the questions that it will raise for them. So if he wanted to engage in such an investment, he would actually have to get a rabbinical court to oversee the decision. And they would have to bring in experts to analyze whether this is in fact for their benefit and so on. There are exceptions to the rule that he can't assign himself a gift which will benefit the estate is actually considered acceptable. So the classic example is if he doesn't have assets for himself and he's representing them in the market and in court or wherever else, and he would represent them better and be better received if he was wearing better clothing. So the estate can buy him a suit, effectively, for him to wear. So in that sense, he's able to assign himself a gift, I suppose. But generally speaking, he can't do that. He lacks the authority to give himself gifts from the estate. Having said that, he does have the ability to accept the gift. The argument made by Boris here is that his mother, of full capacity, gave him the house. If she chooses to do that, and it's demonstrated that she indeed had capacity to do it, he is allowed to accept it. While Jewish law, generally speaking, views the role of the guardian as an act of generosity, that the Apotropis is doing the person a favor and trying to help them out, and it really should be done free of charge, there's recognition that if you don't pay for it, you're not necessarily going to get quality service, and therefore rabbinical courts that arrange a guardian are able to pay the guardian, or families that decide themselves, we would like to hire somebody, they're entitled to pay him, and in that sense, he would be allowed to accept it as compensation for the services he's been rendering. So to answer the question in one line, he would not be allowed to make such a gift on her behalf. However, he would be entitled to accept it if she chose to give it to him.
Okay, thank you. I have another question, and I'd like to play a little bit with the scenario. As indicated, Boris was Jewish, and let us presume that he became more religious, a Baal Tshuva, and his mom's situation deteriorated to the point where there was an end-of-life situation. In her power of attorney for personal care, she made it very clear that she didn't want any extraordinary means to be taken to keep her alive. Boris consults with his spiritual authority, who tells them where there's life, there's hope. The doctor turns to Boris, who's a power of attorney for personal care, explains that mom's situation medically is precarious, and you have to make a decision. Do you want to put in a feeding tube? Rabbi, I'm going to go to you first and say, what is Boris to do? Is it his decision to make a end-of-life decision for his mother in accordance with his own conscience, al pi halacha, or does he have to follow the clearly stated wishes of his mother in her power of attorney for personal care?
Okay. So I would say two things. One is if he actually knew in advance that he was going to be called upon to do something that ran counter to his understanding of Jewish law, then he would be responsible to not accept that position in the first place, to not enter into the position of being an attorney knowing he'd be put into that situation, assuming that he would be asked to do something actively inappropriate. That's part one. But part two is to recognize that the way that you just stated it was that Boris's spiritual authority told him that what he's being asked to do is wrong. But it's worth knowing that there is a broad range of opinion in terms of what can and can't be done. I had the opportunity to ask a question like this to a very significant authority in Jewish law, and I brought it here for the sake of answering your question. So I'll read the case at hand. Rabbi Moshe Feinstein, who was one of the leading figures in Jewish law the latter half of the 20th century, he recommended gently compelling patients to accept life-saving treatment. That's a rough translation of what Rabbi Feinstein himself wrote. And it's theoretically possible for a doctor to do this. However, if this were against the patient's expressed wishes, then you'd be violating the patient's trust, and potentially the physician could lose his license. So would the physician be allowed to act in keeping with the patient's wishes? Would the physician be obligated religiously obligated to save the patient, knowing what he's doing to the patient and what he's potentially doing to himself? And this very significant authority responded to me, the doctor is not allowed to go against the wishes of the patient. Rabbi Feinstein was only saying that one should try to encourage a person as much as possible, but if they don't want, and their request should be honored. That's a verbatim quote. The principle that he's following, which was outlined in an article in 1986 by Rabbi Herschel Schachter, and it's been put forth by others as well, is that generally speaking, the expectation of Jewish law is that if there is a type of life-extending care which everybody, when I say everybody, standard person on the street would want in this set of circumstances, then yes, it's supposed to be used. However, if it's a treatment which, or the person is in a condition in which your average person would say, I'm not sure, then the person is not obligated by Jewish law to accept it. They're within their rights to say that they forego it. So it's not so clear-cut, even though we do believe that where there is life, there is hope, and we value all life, and even the briefest of moments is considered valuable, and there is a range of opinion on what we're talking about. There is a very solid basis to say that if, indeed, Sophia had said to Boris, I don't want a feeding tube, it could be that Boris would be expected to encourage it, but he would not go against her wishes.
Thank you, Rabbi. Archie?
This actually comes up from time to time, as sad and tragic as it may sound. Keep in mind that the overarching goal of the legislation, the Substitute Decisions Act, is it's been described as remedial legislation designed to protect some of the most vulnerable people in our society, and it's to be given a purposive interpretation to protect those at risk. So the stipulation in the twist of the facts that Chuck gave us, it seems to suggest that the wishes of mom are to be given paramountcy and that they're binding. Chuck didn't use those words, but the Act actually doesn't say that. It just says they're required to take into consideration a series of facts or pieces of information or circumstances, including whether those wishes have been expressed. But it doesn't say that you're prohibited from contravening those. And as a matter of fact, I think there's reference in the paper to the public guardian and trustees commentary on provisions of the Act that would be applicable or analogous to the facts as put forth by Chuck, which is that if, let's say the donor had said, forget about life-ending decisions for a moment, under no circumstances do I want the cottage to be sold. I love the cottage. I spent decades, her and her late husband had invested not just money, but a labor of love, had spent years going up there for weekends with the family and had great memories, and said expressly, whatever you do, don't sell that cottage. I want it to stay in the family. Well, as the Public Guardian Trustees commentary says, and I think it's consistent with what the Act says, is you got to be pragmatic, because if respecting that wish is going to have a detrimental impact on the ability of the guardian to properly finance the care required to ensure protection and proper care for the incapable person, the statute actually permits the guardian to say, I have to sell the cottage, if that's indeed what is needed. So a lot of people put emphasis on these wishes as if they're words from Mount Sinai. They're not. They're certainly relevant. They certainly have to be taken into consideration. And so going back to the fact scenario that Chuck had presented, I mean, clearly, if the guardian was concerned, or the attorney was concerned, that they were somehow rewriting the donor's wishes, it's a terrible judgment call to make. But as we've heard speakers recently indicate, the courts are now taking an attitude that the instructions, when they were written by the donor, expressly written about not taking any extraordinary measures to extend life or to cause suffering, often were written at a time when they were capable and not experiencing what they were now presently going through. And so the courts have taken the approach that these instructions have to be viewed in the context, contextually, and that circumstances might change, and that it might very well be a different scenario where this person may not say the same thing. So it isn't as clear-cut as what language is placed in the document, no matter how unambiguous. I was making fun of the language in the postcard, but assuming that there was standard, proper language in the document, I wouldn't necessarily think that it is the end of the story. It's certainly a factor that has to be taken into consideration, and it depends on what the dynamics are. If there is a disgruntled sibling who's been excluded, and remember in our fact scenario, as I recall, Boris, using the power conferred upon him, gave instructions to the hospital staff to exclude the sister for various reasons. It's just that would be yet another factor where a judge would have a hard time overcoming. Yeah, maybe mom said that repeatedly over the years for a variety of reasons, but I would have thought most judges are going to be more receptive and view our clients in a better light if we're so lucky to be able to give them advice before they get to the stage where they got to at the mock trial today, in saying you're not necessarily bound by every last detail that mom instruct you to do, even assuming the court accepted that those instructions were unambiguously given.
But Archie, isn't there a fundamental distinction between attorneys for property and attorneys for personal care, in the sense that the mission statement of, I think it's the Health Care Consent Act, when it talks about the purpose of the legislation, is to promote the independent decision-making person of a person to make their own decisions with respect to treatment. And if that's the case, even if circumstances change, like they do under a power of attorney for property, isn't there a substantial difference when it comes to the refusal or acceptance of treatment, medical treatment?
I'd have to agree with you and say there is a difference. But as Rabbi Torczyner pointed out, things aren't black and white and clear in these situations. And even there's 96 judges, I believe, sitting in the Toronto region. You're not necessarily going to get on the same evidence, on the same facts, and the same counsel. I don't think you're going to get 96 unanimously consistent decisions. And unfortunately, in some extreme cases, judges have gotten so angry at the warring siblings for not being able to cast aside their differences about mommy loved you better than me, and why did you get the diamond ring and I only got the Royal Dalton clown. Whatever it is, my experience is that judges get quite angry and usually use the threat of imposing not their own judgment on it, but rather suspending the powers of the current attorney for personal care and imposing the appointment of the public guardian and trustee to make the decision, which is a complete substitution. It runs a Mack truck through what the donor intended, because the donor intended to appoint a government official as their guardian or caregiver or decision maker for personal care decisions. There would have been a less expensive way to do it.
I should know, you made the distinction between the personal care case and the other cases. So as I understand it, if the doctor were to feel that the patient expressed certain wishes and that the attorney was violating those wishes, I think the doctor has the ability to refer it to the Consent and Capacity Board for review of what the attorney is doing. So that may end up overriding in any case whatever he chooses to do.